Hello everyone, welcome you back to our channel. This is Legal Mindset Adeba, and today we are going in for introduction to law. We are going to look at a very key topic. All scholars of law should understand the sources of law. If you want to understand all the questions in your 4 years, you should understand the sources of law. Now, at the end, I will take you through a very interesting question and tell you how to attempt it. Now, what are the sources of law? If you go to the book of Austin, the book called Province of Jurisprudence, it defined the law as the rules of conduct imposed and enforced by the sovereign. So, we are going to look at the sources of law following their gravity. We shall start with the stronger ones, and we shall start with the Constitution. The Constitution is the grand norm. It is the mother of all laws. And if you go to Article 2 of the 1995 Constitution, it states that the Constitution, it is the supreme law of the land. If any other law, custom, or norm is inconsistent with the provisions of the Constitution, that other law, custom, or norm shall be declared null and void. The Constitution is the supreme law. It is the first source of law. If you go to the case of Paul Kawanga Ssemwogerere and another versus Attorney General, case number 3 of 2000, the Constitutional Court held that the Constitution is the supreme law of the land. It has binding authority on all persons, and any law that is inconsistent with the provisions of the Constitution is null and void, and that all other laws derive their powers from the Constitution. If any law is inconsistent with the Constitution, it shall be declared null and void. For example, in the case of Salvatore Aboki versus Attorney General, Salvatore Aboki and another were convicted of witchcraft. Now, Section 3 of the Witchcraft Act supported that if a person is convicted of witchcraft, their property should be destroyed and they should be chased out of the village. But the Constitution says that every person has right to property and right to life. So, if you chase a person away from their village, the shelter, their gardens, their life is threatened, you have taken away their property. So, Article 3 of the Witchcraft Act was declared null and void because it was inconsistent with the provisions of the Constitution. If we go to another source of law, the Acts of Parliament or legislation. So, Acts of Parliament are the principal legislation. Article 79 grants Parliament mandate to make laws. Parliament is the only body to make laws, and the Acts of Parliament are a source of law. If you go to the case of Miriam Matembe and others versus Attorney General 2000, Volume 3, High Court Bullet, page 84. Yes, court held that the legislature must be left to perform its constitutional mandate of making laws. It should not be intervened. It should not be interfered in with the courts as it derives its power from Article 79 of the Constitution. So let us go to another source of law, case law. Case law is somehow technical because cases lay down principles which judges can follow to decide later similar cases. Now, if a case is decided and its principle is found in a later similar case, the judges will follow the principle in the previous case to decide the current case. The main purpose of case law was stated by Sir George Jessel, Master of Rolls, in the case of Reality, 1880, Volume 13, Chancery, page 712, that the only purpose of case law is the establishment of some principles which judges can use in deciding cases before them. And if you come to the Ugandan case of Remo Richard versus Media Sub-County Local Government, Civil Appeal number 8 of 2014, Justice Stephen Mubiru, one of the most interesting judges, held that whereas the highest court in the ILAC can depart from its decisions, all lower courts are bound to follow the decisions of superior courts above them, only if they can only divert when the cases were decided per inturiam, or they can distinguish those cases. That is case law. We are now going to another source of law, and this source is customary law. So customary law is also a key source of law. We can define a custom as let me say, we can define customary law to consist of unwritten laws and practices that the community accepts as binding and have been in place for a long period of time and do not contradict the provisions of the law. For example, you can look at the customs at bride price where they say give us cows like this, but they are not written. You can look at the marriage customs. Do not marry a person of your totem. Do not marry your sister. They are all customary laws. And if you go to section 15 of the Judicature Act, cap 13, it provides for the applicability of customary law in Uganda. And section 15, subsection 2 of the Judicature Act says that where customary law and common law contradict, customary law shall prevail. So let me give you the criteria followed for a custom to be used by court or to be relied on by court. The custom should conform with law. It should be in conformity with the law. Remember we said any law that contradicts the constitution is null and void. The custom should not contradict the constitution, should not contradict the written laws. Okay, the custom should also be immemorial in nature for it to be enforceable. No one should know where it came from. The custom should be reasonable. Now let us go to another source of law, the common law and equity. On common law and equity, common law means the reasoning of English judges which have established legal principles by constant application. So there are many cases of common law, those ones of Wilmington versus DPP. They were reasonings of English judges. But now, the case of Wilmington is used in many halls of justice. In criminal law, the burden of proof, you hear of it. So, that is common law. Let us now look at equity. We have said common law and equity. Common law tended to be rigid, but equity came in to remedy the rigidity of common law. So where you do not get a relief from common law, equity comes in. There are many maxims of equity. I urge you to go and look at them. Equity follows the law. He who seeks equity must come with clean hands. Equity is equity. Okay, that is common law and equity. Let us now look at the last source of law, the international conventions and treaties. So, if the head of state ratifies those international conventions and treaties, we can domestify them and use them. For example, we have the Ratification Act, and you can also look at the international labor conventions. All those are international conventions and treaties. We follow them. You look at the Wetland Conventions, the Wetland Conventions Act of 1971, which we derived the Wildlife Act from. So, if a question comes and says, examine the primary and secondary sources of law, what we have just talked about are the primary sources of law. And You can also bring in the secondary sources of law. You can talk about the subsidiary legislation where Parliament delegates its powers. You can talk about the dictionaries, the Black's Law Dictionary, very many things. But if a question comes and says that give the applicable, explain the applicable laws, the sources of law, and the applicable laws, the sources of laws, and the law applicable. That thing means one thing, the sources of law. Thank you very much for watching Legal Mindset at the Bar. Subscribe such that we move together. Share with your colleagues if you find this information useful. Thank you.